Item 3, WPA 984 of 943 and 4 by not that granted the time.
Yes.
And I sought instructions, and my lord, they are quite surprised to note that my lords, even if the 2019, my lords, I have got it in writing and produced the document and give a copy to the other side. Even if the 2019 notification is applied, even then they fail. And if the 1st August 2023 is applied, even then they fail. Even if 11th September is applied, even then they fail.
Why?
My lords, I have shown the computation, my lord. I am just handing over. Question of
that they have prepared or who has prepared?
No, I don't see this. I have got it, so therefore it calls for affidavit, my lords.
Let them,
my lords, let's see,
let them file the affidavit, but one thing is very clear.
Permit.
Yes, let him complete your
permit.
Let him complete.
Yesterday, my lord, the submission made by the learned senior was that if this 2019 is applied, then they will pass, and if 11th September is applied, they will pass. But my lord, let's see this tabulation, my lord, their marks are taken into account. And my lord, let's see on the next page. As per CBME 2019 regulation, that is the 2019, 50% aggregate. As per 15 regulation guidelines, it states that in subjects that have 2 papers, learner must secure minimum 50% of marks aggregate both papers together to pass in a subject. Now, my lords, the marks are taken into account, and then my lords will see that after taking into account the marks, it is still found that, my lords, it is less than the pass requirement. Likewise, it is done under the amended regulation also. The last column applies to amended regulation. So, my lords, I am only submitting, my lords, that I may be permitted to file this on affidavit. And secondly, my lords, so therefore, my lords, according to us, irrespective of what criteria is applied, they will fail. And the problem with allowing them to sit to continue in classes is this: there is a clear, my lords, NMC guideline that, my lords, if you do not pass, you cannot sit in the class. So, my lords, my submission is, my lords, this doesn't call for any interim order. My lords, my grant us time to file affidavit. We'll file affidavit next circuit, my lords, it can be decided. We'll file it within a short time.
No, let me understand the computation first.
They have given the computation only in respect of the first petitioner, not in respect of other 2 petitions. No, it's not that. To me, they have not given. I will clarify this thing.
Amresh Yadav.
Yes.
Who is also there? You, Yogesh.
Only Amresh Yadav, Your Lordship, they have given the detailed computation. Not for others, they have given. No, I will show it.
Fine.
It is good enough even for the first person, then to on
No.
suppression should be.
The calculation what they have
Serial number
adopted
3 for
is
Yogesh
little different. Little different in respect of petitioner. That is the reason why I have not clubbed all the 3 petitioners in one petition. I have not clubbed.
In any case,
Let's take up the case of Mr. Yadav. According to Mr. Chakraborty, even
yes, Mr. Yogesh is also failed.
yes.
As per him. Let us take in that. Let us take Mr. Yogesh.
Yogesh is on the 3rd page.
Yes, let us take his example.
Fine.
And just explain that
47% I 94 by of the 200, which is less than 50% aggregate as per 2019 CBME guidelines.
that is not the guideline at all. Okay, let him complete, Your Lordship, then I will explain.
And
Let him explain it as per his
now,
understanding.
My lord will then see the 3rd one. As per amended regulation, minimum 40%.
Yes. So this 41 is out of 100.
Then my lord will see the next part. But there are 2 clauses. Kindly see the last column. But there is one more clause in amended that aggregate 60 is to 40 or 40 is to 60 separately to be brought in theory and practical, in which he's not eligible since he's again declared failed, as he gets in practical only 55, less than 60%. Hence is declared failed as per amended clause 2 in the ratio of 40 is to 60 and vice versa. He gets an aggregate of theory as 47% less than 60% in the ratio of 60 to 40.
It was 50%.
There are 2 criteria that even as per the amended.
No, let's go by the November notification.
Yes.
Let him explain as per his understanding, then I will explain it. What his calculation is absolutely wrong.
Kindly see, my lord, see the November notification. Kindly see it. we have in 2019, my lords, page 123, and my lord may have relevant calculation, a relevant clause at 149.
149.
Yes, my lord. 149.
Yes.
Now, my lord will find internal assessment 50% combined in theory and practical. But then it also says not less than 40% in each for eligibility for appearing for university examination. This is internal assessment. Then university examination, mandatory 50% marks separately in theory and practical. Practical equal to practical oblique clinical plus viva. So, my lords, may kindly then come back to the chart which I have given. Kindly see the chart first page. Kindly see the chart first page. This Amresh Yadav, Amar Shah Yadav gets paper 1 is 41. Paper 2 is 48. Together it comes to 89 out of 200, which is below 50%. Combined is below 50%. Mark sheet is also annexed with the chart.
Yes, it should have been 100
100
plus.
Yes. I'm only submitting minus. Let me find my affidavit file.
I will explain. He has deliberately missed what has been written in the next page. Why, I don't know.
What is that?
Kindly come to page number 150.
150.
In subjects that have 2 papers,
Yes.
the learner must secure at least 40% marks in each of the papers.
Yes.
With minimum 50% marks in aggregate, both papers together to pass in the said subject.
Fine.
It's so confusing that 40% marks is the minimum. If I get 40, it will become 80.
But it will not satisfy the criteria.
Then what is the meaning of getting only 40% minimum marks? That is the reason why, Your Lordship, that is the reason why they have enacted one notification in 1st August 2023, which converted this 40% into 50%. I'll just show you, Your Lordship. Kindly, just give me some time, I'll show that. Kindly come to page number, this is just page number 24. The relevant portion is at page number 82. What the confusion, how they have created, I will prove that one. Page number 82. Now, Your Lordship, what they have done, in subjects that have 2 papers, the learner must secure 50% marks in aggregate to pass in the said subject. Criteria for passing shall apply 50% mark in separately in theory and in practical. Means they made it 50% because that 40% was creating a confusion. So they made it 50%. Now, even then, what they did in the annexure part, Your Lordship may kindly come to page number 99. Kindly see the passing criteria. This all is for first year MBBS. Mandatory to get 40% marks separately in theory and in practicals, and totally 50% for theory plus practical. This is in respect of 1st August.
Now theory is for 100 marks
100
and
marks?
practical for 100 marks.
Yes,
So
I got
taken together, you need to have 50%.
that. I have.
50% means it comes to 100.
No, that is, just a minute, sir. Let me complete.
Okay.
Let me complete. Kindly come to page number 8 of my second petition. Yogesh, look, because he got a little bit more than the other one, so I am showing that. Kindly come to that.
Yes.
Kindly see page number 8. Now kindly see theory. Paper 1 43. Paper 2 51. And practical 55. Now the subject with 2 papers aggregate is 47%. Now obtained ratio is this. Theory and practical aggregate would be 53.6%. How the aggregate is to be taken, that is to be looked into. And how the aggregate, that explanation, that's what Your Lordship, just I will take few minutes, Your Lordship will be very clear about it. Now, again the confusion arose, because if we strictly apply this, mandatory to get 40% marks separately in theory and in practical, and totally 50% for theory plus practical. If this principle is applied strictly, then there will be no meaning of getting 40%, because 40, 40, 40 in practical 40 and 2 papers 40. So it will be 160. 120, I'm sorry. 120 marks will be there in 300. Am I clear, Your Lordship? 120 marks.
Less than the.
Yes. Less than 50% aggregate?
Yes.
Then there is no meaning of writing 40% here. Yes, yes.
So
1 minute, 1 minute. I will explain, Your Lordship, what they have done. Now kindly come to page number 165. They also got confused that how the marks should be calculated. Then they have cleared this thing on 1st September. Kindly see. In subjects that have 2 papers, the learner must secure minimum 40% of marks in aggregate, both papers together to pass in the set subject. Now they are very clear. Means 40-40 I am pass. Thereafter, criteria for passing in a subject. A candidate shall obtain 50% marks in aggregate and 60-40 minimum or 40-60 minimum. Now minimum is 60 to 40. That is, if a candidate gets 60% marks
in theory,
then he has to secure 40 in the practical and 40 or 60. But the minimum word is written in the second one, 60-40. That is, minimum is 40. Here also this.
yes, minimum is 40, but in that event you have to secure 60%.
Yeah,
to make it 100.
Yes, yes, yes. That is what. That is that we have to not 60%, it's 60-40. It's not percentage. It is
ratio of 60%.
ratio.
Yes,
it's a ratio. It's not percentage.
Fine.
Now, Your Lordship may kindly come to page number 8. Now it will become very.
Yes.
Now kindly see paper 1 43, paper 2 51. This is above 40.
Yes.
Both of them is above 40. Now practical it is 55. Now the subject of 2 papers aggregate is 47%. As per this, in subject that have 2 papers, the learner must secure minimum 40% marks in aggregate. Serial number 1. Got it, Your Lordship? If I am not clear, Your Lordship.
Yes, yes.
Now it is 47%. Aggregate is 47%. So as per clause 1, I am passed in this only in the subject. Now kindly come to the second criteria. That is the percentage aggregate. What I have to do. Now 47 is the percentage aggregate of theory. 47 plus 67 I got in practical. 47 plus 57. We have to divide it by 2 and we'll get a 53%. This is the actual calculation. That is the aggregate we will try. Now, Your Lordship, how my learned friend's calculation is wrong, that I will explain. Your Lordship, if suppose we have to get 50%, if we have to get 50%, then it will be 150, 300.
Yes.
It will be 150. How it will be, Your Lordship, 40, 60 and 60, 40. This is a ratio. And 40, 40, 60. Your Lordship, am I clear? 40, 40 means one subject I have to get 40. That is, another subject also I have to get 40. And then practical 60 is the minimum. Now kindly add all together. 80 plus 60 is 140, not 150. If exact 50% if I am applying, it should be 150, not 140. So this goes to show that the aggregate, how we have to derive the aggregate, this is the method of deriving the aggregate. Not that we have to divide 100, 100, 100, 300 and divide it by 2, 150. That is not the method. Otherwise, it will never be 60, 40 or 40, 60. It's very clear calculation, Your Lordship, given by the authorities. I don't think they can, at any point of time, they can explain that how it is coming 140 instead of 150 when we are applying this principle.
Why not have
Now,
two submissions?
just a minute. Let me complete. Now, Your Lordship, the similar issue arose, Your Lordship, with regard to the calculation of marks. This is the decision of the court. Here, the court has permitted even the students to attend the next examination. I am only saying that next circuit my matter will be heard. I am not asking for participating in the examination. I am only saying that I may be permitted to attend the classes. This is the decision.
I,
I'll give you. At that time, the calculation was little different.
Mr. Chakravarti.
There's two submissions, my lord.
No, have you finished?
Yes.
Yes.
Two submissions, my lord. First, my lord, their whole case is based on the September notification being applicable to them. Now that is again a question, this is disputed. Now I have given calculation today without affidavit showing that even if the September notification is applied, still this student will fail. Now this is required to be tested on affidavit.
Fine.
He is unable to explain that his calculation
No, I
is
will
right.
file my affidavit.
No, he is unable to explain
No,
it.
I cannot, within 1 day it's not, not.
You file the affidavit. Since time is precious, let the children attend the class
Separate time.
without any
Without any
equity.
equity.
Tomorrow,
Without any
my,
equity.
today the Pondicherry University is not represented. Tomorrow, if my application is cancelled, what will I do, my lords?
How will you do it? Court order. Court's order has to be
No,
respected.
but they are not here, my lords. Today, ideally, they should have been present because we act as per
They
their.
never used to be present.
If they remain away from the court, what will be done? Just tell me.
By mail, by
Their
everything I have
Once
said.
a
No,
student.
no, you must submit your affidavit, you must tell your say. In the meantime, if the children are allowed to sit in the classroom and this order will not fetch any equity in their favor
Yes.
and subject to the
What harm they will be? I don't understand, Your Lordship. What is the problem with them? It's the
Only
future of
once
the
the
students.
students sit there, or they will have to. We can't tell them tomorrow, my lords. Even the court will not ask them to not.
What is saying? If I fail, I have to leave.
why? There will be no registration in second year.
One other alternative suggestion, my lord.
Yes,
They have made a representation, my lord.
yes.
We can in the
You consider that. You consider
Representation
that.
can be considered in the meantime.
And in the meantime, just allow them to sit in the classroom instead of roaming around on streets. Let them spend some time in classroom. What's the harm?
But my lord, we
What?
clarify no equities will be.
Yes, yes, absolutely. There will be no fear. Yes, ma'am.
Yes, Your Lordship, I adopt the submission made by my learned friend because I am also in the same footing. I also say that they should not allow to sit in the class as because as the little information instruction which I've received from them, they clearly speaks that they are not entitled to as they are declared failed. So in that event also the mail which I have received, they also say that they have obtained that there will be no retrospective effect to the guidelines the petitioner is not entitled to benefit under CBME guidelines. Further, and that
Guidelines
also
for the year.
310, this is the notification of 310/2023. They've in that
We
they've
have
already
not on 310/2023.
but still, they are on the further they also said they should not be allowed to sit as because
You
they are-
submit your
now
application.
yes, Your Lordship, as the Lordship come to an
In the meantime, let them sit in the classroom.
But my lords were
No
clarifying
equity.
that this merely sitting will not make them entitled to give the examination.
Yes, yes.
Absolutely not. It is subject to that, to again subject to the result of the sentence.
They want
Yes, yes.
later on let them apply to the court, but this order may not be
I'm
construed to
not-
mean that they can sit for the
I
exam.
have not
And
even
it is
asked
for
for that.
limited purpose.
My lord.
one small request, Your Lordship, as because I've already said CBSE is in Delhi, and it will be as because the children are allowed to sit in the classroom, or it may for affidavit, it may be 4 weeks, because from Delhi it will be very difficult to come. Again, I have to pay for extension. Then if it is not allowed, and again there will be
Your Lordship, next circuit, the matter should be heard. Because
this
it's
is
not
my
that,
difficulty I have stated.
No, I can
before, Your
understand.
Lordship, because it has to come from
let
Delhi.
it be
Therefore,
first 2 weeks. If they want extension, let them ask for extension. It's the future of the children are
Then
concerned.
this may also be reflected in the order sheet also because
So,
I have stated my
But
difficulty.
I'm doing, you file the affidavit in opposition within 2 weeks from
I'll
date.
try hard, Your Lordship.
And if,
3
it's
days.
not
I will take 3 days only to file.
within 3
Because
days,
I can understand their difficulty. How they used to sit in my chamber, Your Lordship, or ask together to explain me this thing. I can understand their difficulty.
anyway, I reserve my comment.
Your Lordship.
I Ms. Nath, learned counsel for the petitioner, Mr. Shatrugna Chakraborty, learned counsel representing the administration, and Ms. Tasneem, learned counsel representing the
Respondent number 4.
respondent number 4. This writ petition is a manifestation of the displeasure of the petitioner. Of the petitioner, who is a student of medical science and who claims to have succeeded in the first year examination, but succeeded in the first year examination as per rule.
Not succeeded, but.
That is their claim. They are claiming to have succeeded. You are not admitting that. Succeeded
In the first year
examination,
but
but as per rule. But the authority is not considering them, considering him a successful candidate, and he is being denied to attend the class meant for second year students, which is already class meant for second year students, which is already commenced. Class is going on. Yes. Both Mr. Chakraborty and Ms. Nag is seeking an interim relief by the petitioner is seeking an interim relief extending yes relief in the form of order to attend the second year classes. Attend the second year classes. Both Mr. Chakraborty and Ms. Tasneem, learned counsel representing the respondents, other than respondent number 5. Other than respondent number 5, submit that the respondents are inclined to file affidavit in opposition, and the issue, including the interim relief as paid for, may be decided after granting the opportunity to the respondents to file affidavit in opposition. On the basis of calculation as depicted in the writ petition, it cannot be said that it cannot be said with all certainty that the petitioner has failed to bag the required marks to succeed in the examination. Failed to bag required marks to succeed in the examination. Under such circumstances, I am inclined to direct the authorities concerned to allow the petition to attend the classes meant for the second year students of medical science. However, this will not permit the petitioner to claim any immunity or To claim any.
Why not we say not sit for exam? Subject to orders, they can always seek.
If you seek extension, then I have to come with an
Then an
application.
application has to be moved. This order should not be. This order should not be. I don't know that I'm submitting.
Why
This
there
order
should
may
be-
not be interpreted to mean that they can sit for examination.
No, no.
Why
absolutely.
there should be any specific insertion of that kind?
Equity, more precisely, this order cannot be used as a visitor to seek right to appear in the examination. Respondents are directed to file affidavit in opposition within 2 weeks. The petitioner will be at liberty to file a reply there within 1 week,
3 days, Your Worship. Let it be recorded in that.
within 3 days. The interim order will continue, will renew till for 4 weeks or till the disposal of the
Till the disposal,
application.
again and again, I have to ask for extension.
Otherwise,
If they file the affidavit in opposition, it will be heard. I have asked
No, no,
only
my
3
lord.
days time.
It is
let it
easier
be for
for
limited purpose.
Yes.
Let it be extended from time to time.
it is easier for them to file for extension than for us to file for vacating matters. It doesn't happen that way.
4 weeks.
For 4 weeks.
Most days.
Same order,
Yes.
All 3.
What item? Number 4.
item number 4.
Deeply okay.
And your paper, Mr. Chakraborty?
Why not get me kept on record?
No, I am not taking it.
Where?
Take it back. It's Nagir after. So there is no more urgent matters.
Your Worship, one matter. Next to next
I
matter.
want to get myself engaged in that. We have a division matter, we have to finish it up. Which one?
Your Worship, next to next matter. Your Worship.
My lord, I am
Next
studying
Harpreet Kaur.
my matter can be
Yes, your matter. Miss Paul is to be appointed to represent you.
I don't know. I know I'm unavailable.
And you need to pay cost as submitted by your Miss. Where is the gentleman? Bala. You wait. CO 56.
Item number 5, CO 56 of 2023.
A very short matter, Your Worship. 120 days to file the written statement already expired
Oh,
long ago.
that you have to say.
Yes, other
My lord,
side.
in this matter, Siddharth Singha would be appearing, my lord, and proxy counsel for him and the possibility is not a place. Kindly said, mainland, yes, something, Bagalatnama to the said council. He had asked me to pay for an adjournment. Because from Delhi, the Bagalatnama.
Your Worship, already the interim order, already the time to file the written statement expired, Your Worship. Then also after
This
so many
personal
months,
difficulty, I don't know what.
That is the.
let it be the next section.
An adjournment is sought for on behalf of the respondent.
Respondent,
Yes?
respondent counsel, my lord, Siddharth Singha.
Oh, an accommodation is sought for on the personal ground of learned counsel representing the opposite. Let the matter be placed before learned counsel representing the opposite side. Let the matter be placed before the next second. Or listed before the next.
Item number 6.
Your Worship, this is a
CO
very
58 of
serious matter,
2023.
Your Worship.
This matter, my senior was preparing to online for respondent.
Let him appear. Please appear. Your Worship, what happens? The respondent, the opposite party herein, filed a suit for protection against illegal eviction and he paid for an interim order. After hearing both the parties, interim order was not granted, the prayer was rejected. Now, immediately, I filed an application before the appellate court, that is KVN was filed, so that any sort of interim order is asked by the opposite party, I can be given opportunity of hearing. That is the rule of 148A. Now, Your Lordship, he filed the appeal on the next day.
He filed the appeal.
Yes, he filed the misappeal
Oh.
challenging the rejection order on the next day of my filing the caveat.
Okay.
But
So you were the landlord.
I am the landlord.
Fine.
Now caveat noting was not done
Okay.
and he obtained an interim order.
Fine.
After obtaining the interim order, I came to know when the suit or regular date of the suit was fixed. They filed an adjournment petition. From that adjournment petition, I came to know that interim order has been passed because the caveat was not noted and they obtained an ex parte interim order. I filed an application before the learned district judge mentioning that some responsibility is to be fixed because caveat noting was not there and I don't know what is the reason behind not noting down the caveat and the other side has obtained an ex parte interim order. That interim order has to be vacated. I relied upon the division bench judgment of the Andhra Pradesh High Court where it has been held that order, ex parte order means even when the caveat is filed without giving opportunity of hearing to the person concerned, the any order which is passed in an ex parte manner is an illegal order. I relied upon the division bench order. Despite such fact, the court noted down that this is a mistake of the court and therefore kindly see your lordship, this is the mistake of the court. And yes, first of all, I'll take, yes, kindly come to that. Page number 64. Having regard to the submission of both the sides and also
Yes, there no doubt there is an omission on the part of the civil clerk to make a caveat note. When the fact of omission or intention is possible, must be repeat the same.
it was not allowed only because the matter is fixed on 23rd November for hearing and it will be disposed of. Today is 23rd November. They filed an adjournment petition before the learned district judge which was allowed. Kindly see the condition, your lordship. This is very
Lord, I'm for the opposite party. I'm not really audible, my lord.
Let me complete, sir. Let me complete. Next day, your lordship will kindly come to the parent order of injunction. Your lordship knows that whenever an injunction order is passed by the court below specifically, the ingredients have to be fulfilled and described. It is not that prima facie case is there, urgency is there, irreparable loss and injury will be caused, so injunction is granted. That cannot be the order at all.
No, no injunction order was granted.
It was granted. That's what I'm showing. Kindly come to page number.
Granted by
the learned district judge. Page number 58. Kindly see, your lordship, I will
directed to maintain
status quo. Now, your lordship, in order to grant status quo, what type of prima facie observation is there in the order? Nobody can understand. Kindly see this. I'll just place this, your lordship. Permit me to place.
In principle, this interim order should go.
Yes, your lordship. I have the division
Now,
of judgment also.
let's get back to Mr. Jaipal.
Just.
My lord, I'm sorry, my lord, I'm not audible.
Yes,
I could not hear the proceeding, my lord.
you are audible. The thing
I have.
Can you hear me? Can you hear me?
Bro, I cannot hear anything, my lord. I cannot hear it, my lord. I can see the court proceeding, but I cannot hear it, my lord.
Where have you been? Where is your sitting? He is in the comfort zone of his house. Maybe personally. Talk to him over phone. He is not audible. Neither he can listen to any of us. Talk to him and tell him, ascertain if he can come tomorrow.
You know, this is a serious matter, your lordship, and today they have taken adjournment.
No, there is no order of stay.
No stay, then what you saying?
I think, I don't know, only after hearing Mr. Jaipal, we can take a decision. When
My lord,
there is
before passing any order, I may be heard because I'm not clear. My voice is not audible, my lord. Just let me attend my call of my junior. What my lord has said is conveying to me. Just few minutes, my lord. Just few minutes, my lord. Yes, my lord.
due to some technical snag, since Mr. Joypal snag. Mr. Joypal, learned counsel representing the opposite party, is not in a position to make his submission. Let the matter be listed tomorrow as item. Well, he will appear physically or he will assist the court.
I will take instructions. This is my.
Plain copy of the order may be sent to additional session judge and correctional court.
Yes, copy of the order will go to both of them.
Friday, and if it is not.
No, it will go.
Because
Direction
the
has
order
to be-
has to be sent by the additional session judge to
Oh,
the
yeah.
correctional court.
No,
Then only they will.
you may act on the server copy. It will be uploaded by today itself. You act on server copy. You also forward the same.
I will. Though additional session judge may be.
Yes, yes, both of them. The trial court as well as correctional officer. Yes.
Highly.
Online.
In any case, this matter will be disposed of tomorrow. Okay. So you come prepared.
He's also the counsel, your lordship, on record.
You
He
are
can take
recommended
instructions.
for-
Yes.
So you have to come prepared. So what? This is basic thing. 148A is there, you have to take a note of it.
In Andaman Nicobar Islands only he is there.
Yes.
He is in Mayabandar.
My lord, now it's audible. My lord, now it's audible. Now I can proceed with the matter. Now it's audible.
Send a message telling him that matter will be disposed of tomorrow. If he
Yes.
is not audible, he will
Lord, this matter, my lord, matter can be taken up now, my lord. I'm ready. Now it's clear, master. Network issue was there. Now it's clear.
now you can listen to me.
I'm audible. I'm audible, my lord. I'm audible.
Now you tell me one thing, when there is a caveat
My lord.
and the concerned club could not discharge his duty properly, it was a negligence on his part,
My lord.
then this interim order should go.
My lord, no. My lord, kindly appreciate one thing. My lord, it's merely an irregularity. It's not an illegality. My lord, I am again saying it's merely an illegality, irregularity. This one, appreciate one thing.
Then
And
what,
more,
Mr. Jaipal, please, then
My
what
lord.
object of section 140A?
My
What
lord,
object of caveat?
my lord, I admit 148A object is to put a notice or to put a notice to the party who makes a caveat application. I'm conscious of this law, but at the same time, my lord, kindly appreciate one. My lord, now the thing is only one thing. Appeal is pending. By order impugned, the appellate court has clearly held that the other side's prayer for hearing of the appeal has been considered. Let's go with the appeal, Lordship. Next week, any date we fix. I'm ready with it.
Yes, you just make your submission, get the appeal disposed of. But
Yes, but kindly appreciate. Till such time, Lord, I'm a tenant. I'm in occupation. Lord, kindly appreciate that. The appellate court maintained the balance. It's not that they have restrained. Rather, the status quo was that to be maintained, my lord.
Jaipal, when you are in possession, you cannot be evicted without due process of law.
But this is what law says, but the other side is behind me like anything. My lord, kindly appreciate that.
And a district judge is to consider the entire issue in the light of that settled principle of law only. But
Absolutely, my lord.
that giving an opportunity to the caveator to have her say.
But till such time, my lord can grant some protection. My lord, let it be taken up on Monday. I'm coming back on Sunday. On Monday itself, the appeal can be taken up. No, I will not take time. It's a matter of 3 days.
This order should go.
Fine.
No, it
Yes.
can't be time frame done. My lord, kindly appreciate one thing. My lord, one thing. May I say one thing?
Just give me a minute.
My lord.
I am vacating this order, but I am extending some kind of protection that he should not be evicted.
Already evicted, your lordship. That is.
No. I'm in possession. What the other?
Wait.
I'm in possession.
Why? That is the reason why interim order was rejected.
No, it may be. It might have rejected. Only appeal has been taken up. No.
I can show the order of the learned court below, where
It is.
the court has discussed everything.
No.
Every false thing was.
I will get back to you. Don't worry. I will get back.
You know, every false things was placed before the learned court below. They were not able to produce the original lease deed. They were not able to produce any document to show that they have made any payment to me. They vacated.
This will be taken care of by the learned district judge.
Yes, but
Suppose
the point is that, your lordship, interim, after hearing both the sides, interim order has been rejected. This has to be considered. It is not that only after hearing me the interim order was rejected.
I am not getting into the merit of the appeal.
No, what I am saying is, I am saying in a different
Let
way.
let it be considered by learned district judge. In
I
the
have,
appeal.
but this order should go and let it be heard on Monday. I am ready. Why did you file any adjournment today? Let it be heard tomorrow. I have no objection.
Something.
Let me complete, sir. Let me complete.
Advantage of my absence.
Heard.
Taking advantage of my absence.
Should go.
I don't know.
I want this order should go so that the thing which has been done in the lower court should not be repeated. For that only I have come to this honorable court. Otherwise, your lordship, 1 minute, your lordship. I could have obtained a stay of this particular order without issuing any notice to the other side. They have not filed any caveat. I could have done, but even then, I means assured that the other side should be served, and after hearing the parties, only this honorable court should pass the order. So my intention is not bad at any point of time, but kindly see the conduct of the other side. First of all, they have not come with clean hands. Even before the learned trial court, they did not come with the clean hands. The learned trial court noted this particular thing.
Fine, that order is now under challenge. The only issue is, despite there being a caveat, you were not served.
Yes,
That is the issue.
yes, and
For that, this interim order passed by learned district judge.
division
Should
bench of
go.
the Andhra Pradesh High Court has
No, this
specific
order
rule.
should go.
I have Andhra Pradesh High Court on the point. And I have cited, my lord.
And mine is of 2014, and that also division bench. That was single bench.
Hardly matter. Law needs to be seen. The ratio needs to be seen. The ratio,
Your lordship, he is keen about the hearing of the appeal. I am also very much interested.
on Monday, we take, my lord, date on Monday.
Why over his wish? Let the appeal be heard tomorrow. I am
Lord.
ready with the hearing of the appeal.
My lord,
This order should go.
my lord, in such case, my lord, may I say one thing? My lord, may I say one thing? I am raising preliminary objection with regard to maintainability.
Then
Why?
keep on doing it.
So, my lord, order of the district judge is under, it's an appealable order. Its civil division does not lie. Under order 43, my lord has to be approached under the second miscellaneous appeal, not civil division. The scope and ambit of civil division is quite different and distinct from appeal, my lord.
Mr. Jaipal,
Absolutely incorrect
it's-
interpretation.
It's abuse of exercise of jurisdiction. When there is a caveat, I am only on that. I am not on the merit of the order.
My lord, may I say, just 2 days, Monday I will do the hearing, my lord, appeal.
Why Monday? I am ready today also.
My lord, what they will do, my lord, once they get the order, they will throw me out of the land.
And
From the
Monday,
Saturday.
Monday, no,
Why
you know,
they are not on Monday it can be taken up,
holiday, sir.
Fine.
or Tuesday it may be taken up, my lord.
That's what, as per here, his wish only it
No,
will
no,
take.
not my wish.
Yes.
The practical difficulties may kindly be considered. My lord is there. My lord is in highest court of this island. My lord can see this, appreciate this problem.
Allow me to have something. Yes.
My lord, may I say one thing? My lord, may I say one thing? May I say one thing? Subject to what my lord says. My lord, I am in possession. I have an apprehension. If my lord vacates the order, I bow down. I have no problem. But till the appeal is heard on Tuesday, some protection needs to be granted. Otherwise, what would happen, my lord? In the evening, holidays, they would throw me, my lord.
They are already out.
I am
No,
Possession.
no.
Absolutely incorrect submission is making.
We are placed before the trial court. Everything is laid, my lord.
Mr. Jaipal, I am disposing of this revisional application. I am disposing of this revisional application. This order passed by learned district judge is to go. It's a fait accompli. Nothing could be done. If you give us the assurance that on the next available working day, that is,
Tuesday.
you shall appear before the district judge, get the appeal heard.
My lord, my undertaking is recorded. I'm giving an undertaking.
So I will direct the learned district judge accordingly that this matter should be taken up for hearing de novo and appeal should be disposed of.
But till such time, my lord can grant protection. My lord, kindly,
Come here before the High Court. If the
my
entry,
lord, kindly appreciate
what is the use?
asked by my lord. Vacating, I can under
That order.
protection under Article 227, my lord.
Your lordship, this is giving a.
To fall. Heaven is not going to fall for 3 days, my lord.
Oh, Miss Nagi, you just tell me one thing. Can you give me undertaking or your client is ready that he or she will not disturb the position of this man?
Yes.
She is not in possession. I will give undertaking. Wait a minute, sir.
Yes.
I can give an undertaking that I will not do anything to the property.
No, I mean, no, what sort of undertaking is this, my lord? What sort of, throw me and they will not property. It is within the premises. What sort of undertaking would be this, my lord? Something unheard of.
And he wants an order from the court. What is this going on, your lordship?
My lord, may I say one thing, my lord. In such, my lord, I need next matter be taken up because I'm not ready.
No.
Dispose of, I'm with the court. I'm saying, no, let the property pass. But till such time, till Tuesday, heaven is not going to fall.
He is not.
It will lead to cacophony, please. You have had your say. Yes.
Lord, may I say one thing? In 3 days, because I have a time-bound matters fixed in Mayabandar, my lord. For that reason, I've come here.
Yes.
Tomorrow, I'm coming back on Tuesday, Saturday, with the vessel. My lord, let it be fixed on Tuesday, peremptorily by district judge. But till such time, status could be directed to maintain as regard position. But that's what I'm praying.
What is the use of coming me to the High Court?
How on the other side will prejudice? I just fail to understand. Not.
There is a question of prejudice. I have to answer my client.
Even I'm accountable to my client. My lord.
Now allow me to pass the order. Is your client present in court?
She is not there, but I can give an undertaking. I will not do anything to the property.
No,
That-
no, 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 disturb my.
What he wants, he wants.
So, this, so, my lord, kindly visualize it. So they will throw me out, my lord. They will throw me out.
Your lordship, may I
Then the best way is to admit the revisional application with the direction signed affidavit.
Yes, I'm grateful, my lord. It's on affidavit, I'll file my opposition, my lord. It's not an.
and the orders which has been passed should be stayed.
The appeal will not be taken up, my lord. No problem.
I have justified, your lordship. I have
Appeal will be taken up. I want the appeal to be heard out. This is what the also wants. Tomorrow the appeal has to be taken up.
let me complete, your lordship. I have satisfied your lordship with regard to the illegality of the order. So if he wants to file affidavit in opposition, let him file, no issues, but the orders impugned should be stayed.
My lord, both order of the judge and the trial court's order. Let status to be maintained, my lordship. Let both be stayed.
He wants an order like this from this honorable court. I am unable to understand.
Order has been the appeal. If my lord stays the appeal's order, the order, trial court's order also be stayed.
Yes. This is an application under Article 227. No, this is an application under Article 227 of the Constitution of India, challenging the order dated 18th of October 2023, passed by learned District Judge A&N Island at Port Blair. You have challenged the order dated 18th of October?
Both orders I have challenged, your lordship. Your lordship,
18th of October 2023 and 15th of November 2023.
because 18th October I have challenged, your lordship, because there is no reasoning in the order on the ground. Even ex parte order was passed without any reason.
18th of October 2023 and 15th of November 2023. In learned at Port Blair in Miss Appeal number 16 of 2023. Since the opposite party is being represented by Mr. Jayapal, who is appearing in the court virtually, formal notice upon the opposite party is dispensed. Stop. The fact of the case in short is that the opposite party, Ms. Harpreet Kaur, filed a suit before the learned Civil Judge Senior Division, being other suit number 61 of 2023 for declaration and renewal of 2023 for declaration and injunction. Stop. Learned trial court, after considering, it was contested hearing.
Contested.
After hearing both the parties, was pleased to reject the prayer for temporary injunction. Stop. Aggrieved by the order passed by learned trial court, the plaintiff preferred an appeal before the learned district judge, registered as Miss Appeal number 16 of 2023, and the defendant landlady filed an application under section 148 capital A of the Code of Civil Procedure Code. Stop. From the attending facts of the case, it is also admitted that despite the caveat in place, the consent clerk did not make any endorsement when the plaintiff appellant moved the petition for temporary injunction ex parte before the learned district judge. Stop. Learned district judge, in absence of any note regarding caveat, was pleased to pass an interim order directing the parties to maintain status quo. Order to the parties to maintain status quo. Subsequently, on 15th of November 2023, when the matter was brought to the notice of learned district judge, learned district judge, instead of recalling the party order passed in the appeal, fixed 23rd of November 2023 for hearing of the appeal. It is rightly submitted by Ms. Naz that when it was brought to the notice of learned district judge that the respondent defendant filed a caveat and the interim order was passed without serving any notice upon the caveator, the order ought to have been recalled. Stop. Refuting such contention of Ms. Nag, Mr. Jayapal, learned counsel for the opposite party, submits that the interim order passed without notifying the caveator is but an irregularity and not but an irregularity and not an illegality.
Well,
the opposite party is a bona fide tenant and is in possession of the suit property. And his possession must be protected till the time he is evicted following due process of law. Stop. It is further submitted that Mr. Jayapal, the opposite party is ready to appear before the district judge, before the learned district judge for hearing of the appeal itself on Tuesday.
yes, my lord.
Till the time some kind of protection may be extended to the opposite party from being unlawfully evicted. Stop.
Your Lordship, I dispute it, that may
Yes.
be recorded. He is neither the
Yes,
tenant
yes.
nor in possession.
Joining the issue, Ms. Nag submits that the opposite party is neither the tenant under the petitioner nor is she in possession of the suit property.
Yes, Your Lordship.
Suit property is being possessed by you.
Yes, Your Lordship. It's under my possession.
Yes, not she. Suit property, stop. However, Ms. Nag submits that till Tuesday, that is Tuesday is the 28th of November 2023, the petitioner shall not Deal with the property.
Yes, deal with the property in any manner.
In any manner. Stop. Is there anything prima facie to show that you were in possession?
No.
Well,
nothing
documents
there. Document.
it was not made part of this application. I have everything that's not been placed.
No document is there.
Very
My
well.
lord, it has not been placed with the application. Only plain English documents have not been. Let me show the documents.
I will lose the rhythm. Please. Yes. Of right attention. I am of the view that if I am of the view that irrespective of the factum of possession or claim and counterclaim over the possession, the impugned order dated 18th of October 2023 and 15th of November 2023 should not be allowed to remain in force. More so, when it is admittedly a lapse on the part of the court, party should not be made to suffer. At the same time, should not be made to suffer. Stop. Learned district judges, they are requested to hear the appeal itself.
Yes, appeal itself. I am ready. I was ready today also.
On Tuesday.
Yes, my lord.
Tuesday. After hearing learned counsel for the parties. So, till then, the petitioner shall not make any attempt to disturb the possession.
No, your lordship, this will,
No, has to be, my lord. Has to be, my lord. My mind is so afraid of it.
Your lordship, this will create a equity in his favor. He will rely upon this judgment to get an order from the district judge.
That the decision will not be influenced with any finding of the court.
Both of you are senior
Your lordship,
counsel.
this will create a problem for me, your lordship.
Hold on for a minute. Yes. Disturb the possession of the opposite party if she is actually occupying the premises in question, which
Yes.
is disputed by the petition.
Yes.
Which is disputed by the petitioner. Stop. However, I made it clear that this order shall not be considered by learned district judge unknown A&N Ireland while considering the misappeal. The misappeal shall be disposed of on its own merit without being influenced by this interim protection.
I'm grateful, man. I'm grateful.
Which will remain in force till Tuesday.
I'm grateful, man. I'm grateful.
Taking advantage of this sentence, your lordship, she will enter into the premises and I will be in great difficulty. Lady of above 60 years.
Okay.
I'm occupying it.
Police station.
Your lordship, P.S. Abadi.
Stop. The SHO of P.S. Aberdeen is directed. Then we can do one thing.
I have given an undertaking. I will not deal with the property in any manner whatsoever.
Well,
Then, your lordship, passing this order,
you will
she will enter into the
What
premises.
does it mean?
I mean, there's no question of entering.
A minute, let me also clear the things.
Then you come straight and narrow. If she is in position, you will not disturb her position.
But if she is not in position, she will also not enter.
No.
Let it be recorded that way.
Then status quo is the right expression.
That's what
Then status quo is the right expression. You just tell me, does it carry any sense? You do one thing. In the meantime, you select any of your junior friends as officer of the court who will go and have a look at it with this gentleman and come back to say about the physical condition of the property.
Yes, now itself. I'm ready.
Yes, Mr.
I'm ready.
I'm agreeable, my lordship. Everything has to be seen. What is there inside, what business is carrying out, which plaintiff is doing, everything would be. Kindly send it, my lord. Kindly, my lord.
Anybody can be sent. I have no objection.
And I have no objection.
They are not in possession of the premise. It's my position. Before police authorities, she has written that she will vacate on that particular date. All documents are there. That was all. Everything was considered by the learned trial. She wrote when she vacated.
It's all made.
She has surrendered position.
Yes.
Where is that document?
Your Lordship, that document I will supply. It's there with. It is with their list of documents itself.
Give me that document
Yes,
of
yes.
surrendering position.
Yes, Your Lordship. Kindly come to this. This is their own document. I have not relied upon. They have relied upon. Kindly go through that document, Your Lordship. She has written it. I will just.
It's a saloon.
Yes, saloon. She was a saloon.
Not kindly see the other papers. Lease deed.
Let us see your own documents, sir.
Not these are the matter. Not kindly. These documents were not made of this part of this application.
Yes,
Now they say this has been given by me, lordship. Kindly appreciate one thing. My
just a minute.
not desirable, my lord.
I may be permitted to read this particular letter, Your Lordship. 1 second. I may be permitted to read this letter. I, Harpreet Kaur, resident of Phoenix Bay, I was running a saloon in the name and style of Shahnaim, this thing, to vacate the agreement was lapsed on 31st August 2023. I withdrew to take the above station saloon on Friday. I undertake to vacate the above saloon on Friday, 8th September 2023 without flail and with no coercion or any undue influence.
That was undertaken.
And she vacated.
Where is that letter?
That is a letter which she has written and thereafter vacated.
No, my lord. My lord, kindly these facts need to be ascertained, my lord.
One thing may be done. If your lordship is
you just
wants to, Your Lordship, that's what I'm submitting. I never obtained any order at the back of the other side, but they obtained.
I have no habit also, my lord.
Yes, you have obtained an order at my back.
Be taken on Tuesday.
So one thing may be done.
Yes.
One thing may be done.
Yes.
If your lordship wants to give a protection,
Yes.
let there be till Tuesday. Let there be a status quo.
Let there be a status.
Let there be a status. But not that order. That she will enter.
Fine. No, get it in. But status quo actually doesn't carry any sense. Yes. Last step. Tuesday, the parties shall maintain status quo as on 15th of October 2020. 18th of October 2020.
Obliged.
With the revisional application.
Your lordship, till Tuesday.
Till Tuesday.
Yes, that is
20.
specific because Tuesday also if they take time, your lordship, it will be difficult. Only
There's one thing, my lord, kindly appreciate. Appeal is to be taken up on Tuesday. There is an injunction application. My lord, kindly appreciate one thing. If my lord, for instance, district court do not take up the appeal on Tuesday, or if it fixed hearing for passing order to some other day, what would happen? Intervening in lordship.
till Tuesday only. Today they took adjournment.
Disposal of the appeal, my lord. I will do with the hearing.
Not at all, your lordship.
18th of October 2020. As on 18th of October 2023. 2023. Learned district judge shall not grant any adjournment to either of the parties on 28th of November.
Yes, your lordship. And this is till Tuesday, your lordship.
I'm
This
grateful.
your lordship till Tuesday, your lordship.
Yes.
Your lordship. Obliged, your lordship.
I'm grateful. I'm deeply obliged.
You come and fight it out.
Yes, my lord. I'm coming. I'll do it. My lord. I'm grateful. I'm grateful.
Obliged, your lordship.
Revisional application. Yes. Yes, Mr. Shivavalan. Are you ready to accept cost?
My lord,
No.
it is a sheer misuse of process of the law.
Who is representing you?
One.
In other cases, the other day you said some,
Shipra Mandal.
where is Miss Mandal?
Yeah.
Are you ready to represent her? Then I will direct the SLSA to regularize your appointment.
Because I am in DLSA.
That doesn't matter. Are you in the panel of High Court?
No. I'm not expertise in high court, sir.
So you are not in a position to
There
deal
is
with
list
this.
of advocates in SLSA.
No, you cannot deal with this writ application.
My lord, this rate application is not maintainable.
That's a difference.
Yes.
It is difficult because if I am allowed now, in future there are many cases used in every circuit. And I am a lawyer of DLSA. It will
You
be
cannot-
custom, my lord.
You cannot deny service.
My lord, I am DLSA advocate. I will do the service in respect of DLSA matter. I am
No.
not denying.
If court directs you, you cannot say no
My lord, it will be difficult for me.
to deal with your client.
There are
Be straight and narrow,
advocates,
yes.
there are advocates for SLSA.
So what? If she elects always advocate of her choice, that is the law.
That and
And
then,
if she elects you, you cannot say no.
then my lord, here in Andaman, many
But
these
she,
type of clients are there. They will
But
choose many
you-
advocates.
No, I never used to choose, my lord. It's
what is your matter?
Huh? No.
What is your matter?
My matter is,
Huh.
it's actually I
No,
have
no,
filed
I am submitting.
writ application,
Why?
for some
Who
basic,
drafted this?
me, it's me.
You.
Yes. I am
Fine.
appearing in the lower court in person.
Very
In
good.
2-3 matter.